Here at the Sagicor Cave Hill School of Business and Management, located at the University of the West Indies Cave Hill campus, we meet the needs of the upwardly mobile professionals. Our business school functions in an evolving global space where the need to have that competitive edge distinguishes you as a professional. Our academic curriculum offers a variety of programs that gives you that edge. We offer our students a doctorate in business administration. Then, there's our executive masters in business administration. Our Sagicor Cave Hill School of Business and Management is for you. Enroll now.
Welcome to Friday webinars at the Business School UWI Cave Hill. My name is Marjorie Wharton. As always, it is my pleasure and privilege to be with you this morning. I am the Strategic Business Services Director and Clinical Faculty with the Sagicor Cave Hill School of Business at UWI Cave Hill campus, and I am your host for this event today. Our topic is labor relations in the Caribbean. There are many organizations that are facing challenges maintaining their workforce. There are many individuals who have found themselves unemployed or in some other changed circumstances in recent months. Not everyone understands, but the debates and the discussions are raging. This webinar brings together two experienced professionals in the labor relations and human resources management arena. They will be discussing many of the issues that are facing the workforce and organizations today. They will also spend some time discussing the CCJ's ruling in the Chefette case and the implications for similar circumstances in the future. As always, our webinar is scheduled to run for 1 hour and 15 minutes. As the discussion progresses, please remember that you are encouraged to ask your questions as well. And on your screens, look for the option on the bottom that's labeled Q&A. For those of you on Facebook, you can submit your questions to us, and those will also be shared with the panel as we go along. On Zoom, you can also use the chat feature. As we proceed, your panelists will try to respond to as many of the questions as time allows. Now let me introduce your panelists. On September 1st, 2017, Mrs. Sheena Mayers-Granville joined the Barbados Employers Confederation as Executive Director. She has the distinction of being the first female to hold this position. Sheena has over 15 years of experience in human resources and industrial relations, and her passion for people development is pursued through teaching in the Executive Diploma at the Sagicor Cave Hill School of Business. She also sits on the board of the Technical, Vocational, and Educational Training Council of Barbados. Sheena is heavily involved in the management and negotiation of collective labor agreements, and her diverse portfolio of projects includes conducting labor market research, serving as editor of labor publications, chairing tripartite committees, preparing guidance on various labor issues, and leading organizational development initiatives. Sheena holds a master's in labor and employment relations, a bachelor's in management, and a level 4 Caribbean vocational qualification in training and assessment. Welcome to you, Sheena Mayers-Granville.
Thank you, Marjorie. It's good to join you and everyone else this morning for this interesting discussion.
Thank you. Welcome. Our second panelist is Brittany Brathwaite. Brittany is a management consultant rendering services across the Eastern Caribbean and a former labor management advisor with the Barbados Employers Confederation. Having served as National Project Officer with the Caribbean Employers Confederation, she was tasked with overseeing the execution of the International Labour Organization, European Union's EDF 10th Chapter project. Brittany is well-versed in facilitation across territories and has been engaged by the Cave Hill School of Business, by MAP, and several other tertiary level institutions to facilitate short and long-term courses on industrial relations, monitoring and evaluation, and project management. She holds a master's in human resources from the University of Liverpool and a bachelor's in labor and employment relations from the University of the West Indies. She also holds a level 4 CVQ in assessment and internal verification. She is a certified trainer through the TVET Council of Barbados and a certified knowledge manager with the Knowledge Management Institute of Washington, D.C. Welcome to you, Brittany Brathwaite.
Thank you very much for having me, Marjorie, and welcome to all of our panelists and participants.
Thank you very much. Good to have you as well. So to start us off today, I'm going to invite each of our panelists to deliver a few opening comments, and then we are going to go into the discussion. And getting started, I'm going to ask you, Sheena, just to go first, lead us off with your opening comments, and then Brittany, I'm going to hand over to you. So Sheena, over to you.
Once again, good morning, everyone. As we look to discuss labor relations in the Caribbean, I thought it prudent that we can start with just an overview of what's happening worldwide. So as of the 27th of May, the end of last month, 20% of the world's workers lived in countries which required workplace closures for all but essential workers. So we in the Caribbean are not unique. 69% lived in countries with required workplace closures for some sectors or categories of workers, and 5 lived in countries with recommended workplace closures. So generally speaking, both workers and employers have been heavily impacted throughout the world in respect of the COVID-19 novel coronavirus. So the economic activities have generally become lower, affecting many establishments, and this is even beyond workplace closures. So what we are having now is a very uncertain time. Uncertainty around when it will end, what the full impact will be, what the new normal will be. We're operating in an environment that our legislation was not designed to contemplate. Most legislation has no mention whatsoever of a pandemic or public health crisis. The pandemic has basically pushed everyone into survival mode. So when we talk about labor relations, and we are looking at regulating the relationship between management and between management and employees, we're talking about regulating that relationship in an uncertain time where persons are in survival mode. Because businesses are in survival mode, there's a lack of business continuity insurance. Early on in this pandemic, I learned that the word pandemic meant that business continuity insurance could not kick in for all employers, I believe, in Barbados, and I'm certain that applies across the Caribbean. So there's no business continuity insurance. When we talked about disasters or catastrophes, our mindset was focused or geared towards a one-off event. So a hurricane or an earthquake, not something that will last for months on end. When we look at self-employed persons, typically there's no access to unemployment benefits. When we look at the informal sector, and across the Caribbean, we have a large percentage of workers in the informal sector, there's no national insurance, there's no income protection. So many persons across the spectrum are in survival mode. When we look at the employees, the workers, financial survival has been uppermost in their mind. When will I be able to work again? Will I get sick, and will that delay my ability to work and earn an income? We're asking persons to work from home, and in many instances, schools are closed. Nurseries are closed. So then there's a concern about how do I deliver when I have everything going on within my home, a space that was not designed for an adult to work, a child to go to school online and still function normally. So we're operating in that level of uncertainty. And then in the workplace, there are so many considerations. There are the issues and questions. There's job security, wage cuts, layoff programs. We have the BOSS program that is here in Barbados. We have restricted operating hours. And we are now asking employers and employees to negotiate and navigate in this new environment. So we've had our challenges. So I'm going to pause there and let Brittany jump in, but those are my opening comments in terms of the operating environment and the challenges that both the management and employees find themselves facing that we have to find common ground on.
All right, well, thank you very much for that. That's definitely a lot for us to consider as we start off, and certainly it paints a picture of where we are right now. So, Brittany?
Sure, and Sheena really laid a good foundation on it, which I will build. Sheena gave some statistics about unemployment across the world, and what I'm going to dig down into is the type of employment and how the type of employment has actually been impacted. She mentioned very accurately that across the diaspora, that we do not have legislation that generally treats to contractors or forms of employment that is outside of full-time employment. And when we look at the figures coming from the International Labour Organization, in the 2.7 trillion people who have been impacted by COVID by job losses, 197 million of those have been full-time workers. And when we look at the projections coming out, so of course, the Caribbean is not exempt from these figures. You can anticipate that the majority of persons who have lost their jobs, at least in the private sector, and who may be suffering from job cuts and short time and different types of cuts to their work, will be full-time employees. Now, I think it's very important to set the tone for where we are going, because we know what exists. We know there's a lack of legislation. We know there are the ongoing issues. What will it look like, and what will the re-engagement of a number of people look like beyond COVID? I think that's critical for us to assess across the Caribbean. And before COVID-19, the ILO Future of Work Centenary focused heavily on how labor will be engaged very differently, particularly in our region in the future. I think COVID-19 has catapulted the Caribbean into recognizing that contract labor and consultancies and rendering short-time services may come very soon for us. So and the figures that we're looking at in terms of here in Barbados, I should say, in terms of the number of unemployment claims submitted between March 1st up till today's date is around 43,000. Now that's about a third of our workforce. And a very small percentage of those persons have actually identified on their papers to be casual workers. The majority of them are full-time workers. Even if we see a small percentage of that 43,000 being made redundant or losing their full-time employment, there's a very high possibility that the way in which employers will seek to re-engage people for their services will no longer take a full-time purview. And I think what we need to be prepared for in labor relations are two critical things. From the employer standpoint, how do you safely and legally engage people for their services outside of full-time contracts? How is that done in the context of the legislation that in many cases, and Sheena pointed it out, our national insurance security net in many Caribbean countries, unfortunately, don't cover persons in the informal sector and or those persons who are under contractor contracts. So that is going to be a huge consideration nationally and regionally for us. We also have to look from the employee standpoint and from the union standpoint. How do you start to collectively bargain or how do you start to collectively share issues for an extremely dispersed workforce? So imagine that you have thousands of contract workers versus 70 persons in one staunch workplace. How does the union, take their services to their people in a very dispersed but consolidated way? And what does that look like for us in the region? So I think Sheena looked at the macro level, but I think those are some of the micro level, domestic, and even to a certain extent regional issues that we have to look at in relation to labor relations. And I'll stop here so that we can jump into some questions and more dialogue.
Thank you very much. Certainly the comments that both of you have shared and the perspective that you have given us is one that shows, well, it shows two things. One, that it's really a dire situation globally. It's a dire situation in the region. In no way is the region's legislation or employers or I guess facilities, support facilities prepared for it. So I have a question that immediately comes to mind. If the legislation is not prepared, but this is the reality that we're facing, where do we go from here? What is expected to happen next?
I think Sheena and I were both looking to see whose mic would on.
I know, so I'm not even sure which of you may be in a position to answer that, but what really needs to happen, given that we don't have the legislation, but the workforce is changing, and it seems also like the nature of work is changing, and there's all these things going on in our environment.
So I can give a generic answer, because I'm sure from an employer's perspective, Sheena can share some information, and I also know the BEC has been circulating a number of surveys, so I think she can share some very specific information with Barbados. But I think it's going to be very important that in terms of labor policy and the creation of labor policy, that across the region we move to research-driven agendas. And move to ensure that we're actually creating labor that meets the labor demands versus supplying labor that does not. Because now high volumes of unemployment in the COVID, in the context of a pandemic, it's not unusual, because I mean, businesses will close. What we have to discuss is the agility of our labor market and how agile are our laborers based on the educational background that they have had. And I think that is very, very important for us to consider across the region, because if we're creating an agile workforce, we have people that can be agile in the times of crises. So and I'll use tourism, for example, because across the region, tourism has been an extremely hard hit sector. And I know here in Barbados, for example, in the first 3 weeks, the 20,000 claims that were submitted were solely from the tourism industry, which tells you, how tremendous our sector is. But what we see in those sectors are, unfortunately, a number of low-skilled workers, and a number of low-skilled workers who have also, unfortunately, not acquired skills that can be utilized outside of the sphere of tourism. And what that means is that we have to, from the community levels, from an educational reformation level, we have to be looking and researching as to how we can equip our people, because primarily in Barbados, our people is our resource. We don't have oil. We unfortunately don't have a lot of physical resources. So how do we have a room attendant? How do we have a room attendant to have an agile skill? And this may be a room attendant who is trained in, making beds up and cleaning and etc. How do we take a room attendant in the context of COVID and give him or her a skill that is transferable? And when we look at that, when we see the research that's being executed, information technology is a global transferable skill. And we're not talking about coding or being able to write code, but we're talking about providing a house attendant or a room attendant with the opportunity for a simple marketing course, so they can, execute services of marketing for small businesses or for Airbnbs. Because as we see in the markets, the hotels aren't reopening as soon as the villas and Airbnbs are reopening. And where there's a dearth of labor across the Caribbean is for persons who can actually manage Airbnb and villa rentals and manage those properties. There's a dearth of talent there, because you don't usually find a person who has the knowledge of a room attendant but can also market that product. So that's what I'm talking about in creating an agile workforce. And it's of course not as simple even as discussing here, because it means huge educational reform and huge labor policy reformations. But it starts, the basis of that is ensuring that our research agendas are driven by what the demand looks like for labor, and not just now, but 10 years out, and what it will look like, versus creating educational programs to supply the labor supply in 3 months, because in 3 months it'll change, and we've seen that with COVID.
So I'll continue from Brittany's comments. So Brittany, I would say a lot of what you highlighted related to workers becoming more agile. So I want to speak to the organizations now, which also need to become more agile. The truth is, legislation will always be behind current events. Because what will happen is the legislators will see what's happening in the environment and seek to respond by writing legislation. However, we know that our environment is changing so rapidly. The truth is, it will never contemplate all of the eventualities. But what we need to do is to ensure that our organizations are in a position to respond. What I will say, we did a needs assessment survey. The percentage, the number is not coming to my mind right now, but a very high percentage of businesses responded that they did not have a business continuity plan. And they didn't even have one in the context of a natural disaster. So that is concerning. The reality is, as a business, you need to start looking at your environment, constantly doing that environmental scanning to see what will be coming down the pipeline that could potentially impact you. There are many organizations who closed their offices, went to remote work before government instituted national shutdowns. And they would have done that because they saw what was happening internationally. So many of them did have, were operating in many locations. So obviously they're responding to more than what's happening in a single country. But looking around, they saw what was happening. They realized we need to ensure that we can operate remotely and put those systems in place before government issued national shutdown orders. And that's what we as companies need to be doing, looking to see what's happening and instituting our response before we're caught with our pants down, using the parlance. So looking at your organization, you also need to set up your policies within the organization. You can't rely on legislation to do that for you. Of course, your policies can't breach legislation, but I'll tell you, very often your company policy can be more stringent or more lenient than what legislation provides, and you still not breach legislation. Let me give you a classic example. Legislation doesn't tell anyone about alcohol use in the workplace, but employers can have policies that determine how they treat to something like alcohol or substance abuse within their workplace. So once again, the legislation might be silent, but you can speak to that. And many things might not be explicitly stated in occupational health and safety legislation, but implicitly you know that you need to do certain things within your organization. So I'm just showing you how organizational policy can definitely go beyond what legislation requires. One of the things that I am starting to see, and I want to caution employers about as well, is trying to go back to the way things were. So as we lift up restrictions, as restrictions are lifted and more persons are allowed back into office spaces, into workspaces, wherever those may be, the reality is it's not going to be the same. And while mentally that is a leap we have to take it. And what Brittany was mentioning is looking at new forms of labor. We know that those things were coming down the pipeline, and now it's going to be accelerated because of business demands and the need to be flexible. But don't think about it as a bad thing. What we have to do is to start thinking about how do we creatively respond to the issues that we face, and not just try to go back to the way things were. I will say, for example, the Barbadians who are part of the conversation here this morning might be aware of the BOSS program, the Barbados Optional Savings. I can't remember what the two S's are, maybe savings scheme, but that I believe is a creative response to an urgent need that the government had. An urgent need in terms of cash flow, operations. They want to maintain employment levels, but knowing that cash is needed to be freed up to do capital projects. So a creative response to a need. And that is where businesses need to operate, in that space where they're looking at, okay, how do we maintain employment? How do we continue to deliver our service, but in a creative way? And I would say labor also needs to do the same thing. And Brittany, you alluded to that. How do we deliver what we've always delivered in a new format to meet the changing needs? So that's where I think our mental space needs to be.
All right, and again, you certainly have painted a very, I think, different picture than what we are used to seeing or dealing with as employees or as individuals, management working in organizations. Now, both of you have referenced the fact that we're really looking at, and I'm just looking at some notes I made here while you were speaking. You mentioned the fact that we are likely to be moving out of the way we are currently working. So traditionally, we've had situations where an employee may have a job, they're considered a full-time employee, they are expecting the organization to provide workspace and to provide some level of care for them while they are within the organization's walls. And that's where a lot of the issues related to occupational safety and health would have been clearly aligned. Now, in your opening comments, you mentioned, Sheena, about changes with regards to that now. What are some of the perhaps occupational safety and health issues that are arising as we're going into this new form of work? So for example, if the organization was traditionally expected to provide me with ergonomic chairs because I had to sit at the computer for 8 hours a day, but the organization is now still expecting me to sit at a computer for 8 hours a day, but I'm doing it at home, what may be the organization's requirements? What is their contribution expected to be in that situation?
Well, I would say that's an easy one for me, Marjorie. I would tell you to take home the chair.
Okay.
And fair enough, people have had those conversations. Mm-hmm. You are correct. As an employer, you do have certain requirements, so you need to make sure that your employees can function safely and maintain their health while they're performing their duties. And for those persons who are working from home, employers might have done various things. So if you had a chair or workstation that was specifically designed for you, there may be elements that you can transfer to your home. There are some who would have given guidance in videos. There's a wealth of information available online, helping persons with when you're setting up your workstation at home. These are some of the things to consider. So you help the employee along in the process. There are others who would have consulted with employees to find out what would your work schedule look like? What is an optimal work schedule for you given childcare requirements? And given schooling requirements, because that is a very real consideration. And some employers would have offered some mental health support. So providing different avenues for employees who might have been having some challenges dealing with the rapid changes and some of the concerns around those changes. So it's not just remote work, but then persons are very fearful for their own health, given that it's a public health issue that we're dealing with. So as an employer, just because a person is not physically within your space doesn't relinquish you of that responsibility. What we would have advised persons is to utilize the technology. The same way how you might walk over to a person's desk to ask them how they're doing. No, you can't do that anymore. But if they're at their home, reach out to them and find out, okay, how are you managing with the workload? How are you dealing with the stress of the situation? You don't need to pry necessarily, but you need to touch base and have a gauge of what's happening with your team and to make sure that you remain connected. There are some persons who suffer from the loss of that, being in that physical environment and having persons around them, and especially so when they live alone. It's one thing to be on a shutdown when you have family members within the household. It's another thing when you are in a space alone for weeks on end. So to do that, to reach out and have that communication channel open with your employees as they go through this time. There are some health and safety concerns in terms of returning to work. There are persons who would be very concerned in terms of interacting with the public, interacting with co-workers, maintaining the hygiene levels within the office space. And those are things that you have to work through given the context of your individual organization.
Okay, all right. Thank you very much. And we have a question. I did receive a few questions before the session. We have one that was specifically tailored for you, Brittany. Someone is asking, post-COVID, how does an individual employee who had a pay cut for an open-ended period begin the process of discussion or renegotiation for salary restoration? So as we are now in this situation where we are looking perhaps at moving into new work orders and so on, how does an individual have a conversation with their employer where they're moving into that kind of discussion and renegotiation for salary restoration?
Now, the general advice, I mean, after I'm finished, Sheena can also lend as to what, from an EO perspective, they're advising employers. But the advice that I am providing to clients across the region is that you avoid those indefinite types of situations because COVID is a period through which we are all experiencing challenges. It's always best, particularly when you're treating to a contractual obligation, which is paying a person's salary, and you're legally bound to pay that salary. If you're going to make a change to that legal obligation, that you provide a time frame as to when or how long that change will apply. And in some cases, you know, if it has to change month by month, that's fine. But when you're making a change to a person's salary and you're leaving it open-ended, I really do not advise that in any case for an employer, even if you have to project it out for 6 months. So I would say to the person answering the question, to ask the employer to provide an end date or a date for further discussion on this. When you leave those open-ended salary change discussions there, and I'm not even quite sure how you would word documentation saying I'm going to cut your salary indefinitely, because to make a contractual and legally binding change, it needs to be mutually agreed. And therefore, employers need to be very cognizant as to how they're going about doing it, just to ensure that they don't run themselves into trouble and legal trouble post the COVID situation. I'm sure that in most cases, persons may have signed the document, which of course they have proof of their consent. But when you do that indefinitely, then we have to look at the softer element of things. There's still people who are expected to produce. You of course still have persons who have to be productive in working environments. And it's just not, it doesn't create the most conducive environment when you just say open-endedly that is going to be the case. So I would say to the person posing the question, as soon as possible, go to your employer and ask them, rather than having it open-ended, to provide a stipulated date for further discussion on the same, even if it's the next financial quarter or whatever that may look like.
Okay, so just as a follow-up, so if the person perhaps was not aware that they had that option to say that it should not or must not be open-ended, if they're in that situation now, they should still go have the discussion and put it on the table as something that they want to come back and discuss. And they're well within their rights to do that because it should not have been open-ended.
Well, if they would have mutually agreed to the open-ended arrangement, it's not that it should not have been done. If the employer approached it correctly and they got the mutual consent, it's not that it should not have been done. What I am saying is that it's better where you have a legally binding agreement not to do that. But if they consented to it and it's been mutually agreed, the only thing they can do now is to go back to the employer to say, well, you know, I'd prefer if we were to create a timeline on this, because they would have mutually agreed to the change. Sheena, you want to add?
Okay, all right.
Yeah.
Thank you for clarifying, Brittany. Go ahead, Sheena.
And it just, I'll add a bit more to that. I do echo Brittany's sentiments. We have been advising persons that any change to an employee's remuneration needs to be mutually agreed. But I do know that it might not have been that the intention was to make it indefinite, but that in the conversation, a review date never came up.
Right.
So I would suggest that the person have a discussion around a date for review. So basically you're saying, I understand that given the nature of what is happening, we've agreed to a salary cut. However, let's have a timeline to review what would happen in terms of any restoration, any extension, that there's a point for reviewing the process.
Correct.
Okay, all right. Well, thank you for clarifying that, because I think at least it gives anyone out there who finds themselves in that situation an outline of what action they can take, what steps they should take next, and to let them know that they're well within their rights to initiate that kind of discussion. So I have another question coming in. How can trade unions assist during this period of uncertainty when businesses are so focused on survival?
So I'll jump in here and say that trade unions do have a role to play, and I have personally witnessed them playing that role. Now, businesses are in survival mode, but businesses need people in order to operate. So the trade union has a role in terms of educating the workforce. I'll start there. When we had the first, well, I wouldn't even go to the first diagnosis, in-country diagnosis, but as the pandemic drew closer to the shores, we had frontline workers. So we had workers at the airport, at the cruise terminal, and that would be throughout the Caribbean. And those persons would have been interacting with people coming from countries where there were coronavirus diagnoses. And we would have seen the trade union step into that space to help in terms of educating them on procedures, policies to follow. Because let's face it, very often people have a wealth of information coming to them from various sources, and they want someone who they trust is working in their best interest to help them to filter that information. So something as simple as, should you wear gloves or not? I mean, there was a whole debate about that. And the trade unions were able to step into that space, and where you had workers being uncertain, to be able to explain to them or to work alongside management to explain, okay, this is why we're doing the things that we're doing. So trade unions do perform that function in terms of educating the workforce and helping them to understand some of the things that are transpiring. When it comes to reframing sometimes job roles and job functions, the trade union also steps into that space. Because of COVID-19, sometimes persons have had to change what they traditionally do. And then you're seeking to have mutual agreement maybe with a group of employees. So instead of negotiating with 10 employees, you know, negotiate through their representative, the trade union. So you're not having 10 individuals trying to come with competing interests, because as individuals you have different interests, but the employer can have the conversation with the trade union to have an agreement that would then apply across that group of workers. So the trade union does have a role to play, and I just mentioned in terms of within the organization space, but then nationally they also are representing workers at policy levels, etc. When we have discussions on national policy, on jobs, on any wage freezes, wage cuts, potential, well, wage freezes because there's no wage increase, those types of discussions, we need to have the trade union on board because they need to, they're speaking for the workers, and they also need to have the workers buy in to any decision that is ultimately made in the best interest of the country.
Okay, thank you. I have a question from someone who is working in the public sector. I'm not sure which territory which island she's in, but she starts her question this way. I work in the public sector, and since the emergence of the coronavirus, a lot of issues have arisen. A few of them are now being considered by management, and they are as follows. And one in particular that she mentions is the state where management is taking disciplinary actions against staff who may refuse to work the hours imposed by the employer because of their concern that too much exposure poses a threat to their family's health and protection. Is there any advice or feedback that you can perhaps share with the person who's asking that question?
I believe in most territories where they've started reopening efforts, they have done so after issuing national protocols around health and safety, around transport, around varying areas. And therefore, of course, we are missing some of the details around that specific question, but I envisage that there may be sanction and disciplinary action because the employer may have taken all reasonable steps to ensure that the employee is in fact safe, getting to and for work and functioning in the working environment. And therefore, the expectation and the rightful management expectation is that the person comes and renders services. Now, if there is a specific medical condition that is preventing that person from rendering services, or if there, are persons within the household who are within the vulnerable grouping, and that person can produce documentation that exposure, can harm persons or occupants in their household, then that prompts a separate conversation. But I am assuming, based on the limited information that we've been provided with, that the disciplinary action may have been sanctioned because the employer, in this case being the state, would have taken all reasonable steps to ensure that the working environment is safe and healthy and is a well-working environment for that person. And therefore, the refusal then to render services is not based in any absence of the employer action, but more so out of the fear of the employee. And the fear of attending work really isn't a justifiable reason. That's why I said, you would have to base your non-attendance in either a medical issue, incapacity, being in the vulnerable group, or something that is actually justifiable, but not fear.
Okay. And another part of that question that I would...
that question as well, though, to that response, Marjorie, sorry.
Sure.
But I know the question was specific to the public sector, but we have to also be careful of those instances in the private sector. And the reason being, many employees might have been placed on layoff, and there is a time limit to that. So where an employer is providing work for you and they're able, and then you refuse to render service, then if the employer does not respond, they could end up finding themselves with a severance liability in a situation where they were able to offer work to the employee. So there are some other considerations that could occur in such a situation.
Okay, thank you. And another part of that question, she has mentioned that they're discussing as well the requirement to take vacation leave during the pandemic when the actual purpose of a vacation would be defeated. So I have heard several people from different organizations, different sectors and so on talking about this issue. The fact that there seems to be this idea that because you're working from home, that vacation almost goes out of the picture. So what is the perspective perhaps as individuals in HR, understanding how vacation works for the employee and how it is considered in an organization? What should be the perspective about vacation leave?
The legislation across the region, and we can make reference specifically to Barbados, but I'm also familiar with Jamaica and Trinidad, makes specific reference to vacation accruing based on services rendered. So even if you're rendering those services from at home, you still accrue vacation. So I'm not sure from a legal perspective that it has any impact on vacation unless you are actually on layoff or if you've been terminated. But I'm not sure how there would be a legal argument that a person who's continuing to function, even if they're doing that remotely, that it could impact their vacation accrual.
But this is more about taking the vacation. So the discussion, I think, yes, the requirement to take it during the pandemic.
Well, again, most legislation and even in the labor codes across the region, it speaks to the approval of the vacation being provided by the employer. So it may be your desire to take it during the pandemic, but the employer still has to approve that. And most legislation also has a notice period for both the employer and the employee to adhere to. In Barbados, the employer has to give at least 10 days notice if they wish for you to take that vacation. And there's similar or likely clauses across the region. So it would be less about the desire to, and it would be more about mutually agreeing on when is best operationally and whether the company can approve around that same timeline. There's absolutely no restriction in taking it during the pandemic, but it may not be efficient or it may not be best for the employer to grant it during the pandemic. So that may be the case.
Okay.
And Marjorie, I've heard some comments from labor circles saying that person should not go on vacation during the pandemic because it's not a vacation because there's nowhere to go. However, as I explained to some, the many employers sought to utilize vacation, and typically the employer, as Brittany said, has the final decision in terms of when an employee goes on vacation. So many employers sought to utilize vacation as a means of providing continued payment for employees during restricted business activity. So I've had to close my business because of a government imposed lockdown. I could place persons on layoff, but depending on what that person's situation is, their financial situation, how long will they have to wait for NIS payment, and then it's going to be a reduced payment. Some employers said, okay, I can give you at least some of your vacation. That way when the business is closed, you've had some cash in hand. Even if I have to extend it with a layoff, at least you would have had some funds in hand to begin with. So for many employers, it was an attempt to assist employees through a difficult time. And also employers looking down the road saying, I can't afford to pay an employee now, and then have them have their full vacation allotment, say later down in the year. I can't carry that financial burden. So finding a way to, once again, maintain employment and provide workers with some level of financial income during the trade restricted activities.
Okay. All right. So thank you for providing that clarity. I have another question here. Someone has indicated, I have a friend in the hotel sector. Please clarify the legislation. Is it the law of the land that after 6 months of unemployment, you are entitled to severance?
Well, the current, I see Sheena. Well, maybe I can speak to the current, what is current, Sheena, then you can speak to the prospective. So the current Severance Payments Act speaks to 13 continuous or consecutive weeks, and thereafter, with the employee given notice to the employer of their desire to collect severance, that is possible, or 16 weeks, and that would be 16 broken weeks in a 26-week period. So no, there's not the 6 month. I think what you may be speaking to may be the benefit period. So unemployment is currently paid out for a maximum of 6 months through the National Insurance Scheme. That exists. But in terms of severance, the ability or the eligibility around triggering the severance is 13 consecutive weeks on layoff or short time, or 16 broken weeks in a 26-week period.
Okay.
And I will confirm that all current labor legislation in Barbados remains in force. While there is some level of discussion, I won't go into any detail, but there is some level of discussion because we know that some sectors are particularly hard hit. And say if you had all the tourism workers claiming for severance at the end of that 13-week period, we would have a very severe and dire situation in Barbados. Let's face it, Brittany mentioned that about 20,000 hotel workers were laid off early in the pandemic. I think out of about 83 hotels, we might have only 2 or 3 that are open. So just to give you those numbers, imagine if all of those workers wanted severance all at the same time. And either employers having to find that cash flow and therefore not being able to potentially finance a reopening, or the claims being directed to national insurance and what the potential payout from the severance fund will be. So those are some real considerations. The legislation remains in force. If there's any change to the legislation, it would have to happen in very short order, and I'm sure it would have to be widely publicized. And any change to labor legislation, I'll tell you, goes through the process of tripartite consultation, and that would be ongoing. So all legislation remains in force as of today. Any change would have to come in the near future, and the public at large would be advised.
Okay. All right, another question coming in. Someone wants to go back to the pay cut issue. In the case where there was a timeline given, say 3 months, so you had a definite end date to the pay cut, 3 months. At what point after that timeline has lapsed should the employee approach the employer for feedback on the restoration of full salary?
I mean, ideally, it should happen actually before the exhaustion of the period, because you'd want to have consultation about whether it has to be extended, if the restoration will be part thereof, if it will be full, and in most cases, it should happen before the exhaustion. So if you've gone past the date, I'd say you should raise, the conversation as soon as possible.
Okay. All right, thank you very much. And we have a question about a company perhaps not being so agile. If your company is still not utilizing technology to provide support to staff and to the public, how do you encourage management to seek this direction of agile changes and digital transformation? And I see both of you are smiling.
You use your powers of persuasion, whatever they may be. And there are some employers who may not be very au fait with the technology themselves, and that hinders them, and they don't fully understand the power or how it can be utilized. Or sometimes they are aware that these things exist, but they might see the cost as prohibitive, because in some instances, information technology can be quite expensive. What you might need to do is have some discussion with your co-workers, with your supervisors, so middle management, even if it's not senior management, but looking at some workable solutions and presenting that for discussion. Because while you might have some idea of what can be done, you still need to understand what are some of the issues that might be preventing the company from fully implementing those ideas. So to understand the other side, so you can come up with a workable solution and then demonstrate how it can improve the business and obviously seek some business continuity in the current climate.
Okay. And we have 2 questions that have returned to the issue of vacation. What about those persons such as office attendants and office assistants who cannot work from home? Can we ask them to take vacation during this time? That's one question. And the second one is, what if the employer requires the employee to take vacation while they are in lockdown? Can the days be legally deducted? So it's not that it was that the employee requested it, but the employer is requiring the employee to take the vacation. Can they be legally deducted?
No, I know we're having a conversation about the Caribbean. If that person is in Barbados, I will direct them to the BEC's website. That's fine, Marjorie?
Yes, of course.
Okay, because we did issue some guidance to employers, and it would be applicable from an employee perspective, because then we can see what an employer is entitled to do in terms of utilizing layoff or vacation during the period of lockdown. But essentially, the legislation doesn't require employers to pay an employee when they're not at work unless they're on vacation. So the legislation is not going to say, when this person does not render any service, you have to continue to pay them. So then what do you consider for that period where the person cannot deliver service? So whether it be the person who can't work from home, or as the office is reopened, for some reason the person is not able to physically come into the office. You have to consider, one, as an employer, do I want to put this person on vacation? Am I within my legal rights to place them on vacation? Yes, you have the right to determine when an employee goes on vacation, but there's usually a notice period that you have to give the employees before making them go on vacation. So am I within my right in terms of providing adequate notice for the employee that they're proceeding on vacation? If I can't do that, can I place the employee on temporary layoff because the business has shut down? Or when I say shut down because of the lockdown period, because it's closed because of lockdown, or as the business has reopened but maybe under restricted hours because of a government mandate, and I can't have full employment, do I place persons on layoff? Some companies are in a financial position where they can continue to pay workers their full salary during a lockdown time frame, and if they can, most of them will. And consider that special leave with pay. You've given a person's time off, and you're giving them time off with pay, so that's fine. So those are usually the three things that can be done during the period: either temporary layoff, vacation if within the legal parameters, or leave with pay. Those are usually three options available to employers.
Okay. And we have two more, thank you. And we have two more questions about pay cut and so on, and unemployment. So here's the first one. In respect of a pay cut, is an employee entitled to be reimbursed that lost money, quote unquote, given that their contract speaks to being paid specific remuneration? So if you were in the situation, your contract has an amount you're supposed to receive, but under these circumstances, you were asked to take a pay cut. Is the employee entitled to be reimbursed to that lost money?
If you mutually agree to the pay cut, unless around the documentation issued in that mutual agreement says there will be retroactive reimbursement, then no, the expectation can't be that the reimbursement will happen. And to be very clear, remember we explained that making this change is in fact making a contractual change, so it requires a mutual consent. And therefore, if you agree just to the cut, then that's what you're agreeing to. Some employers I've seen create agreements that are quite innovative. So rather than providing, and I would actually say the BOSS program is one of those very innovative programs from a public sector perspective, but I've also seen it done in the private sector. Whereas rather than having the monetary compensation for the period, they're promised equity or shares in that amount for the period. So you receive X in monetary and the remainder in shares. But if you've simply consented to the pay cut being the simple pay cut, then no, you should not expect something that was not agreed at the time of the pay cut.
Okay. All right. And the second question is this: for clarity, because of the number of persons unemployed, what happens after 13 weeks?
So So currently, and as Sheena said very clearly, the current legislation applies. So after 13 consecutive weeks, right now, as worded in the legislation, an employee can make an application to their employer to claim severance. An employer, however, can say, you know, they are going to pay an employee to break that period. I also saw another question in there which applies to this question, whether an employer can pay a short week to break that 13 week, those 13 weeks, and that can happen if an employer does that. But right now, to answer the plain question, based on the legislation, if you've been on layoff for 13 consecutive weeks, yes, it does give an employee the right to claim for severance to their employer. But if the employer responds to that claim by saying, I either have a short week of employment to offer, or I am going to pay to break, I'm going to pay to break what has been these consecutive weeks, that claim can in fact be null and void. Okay. And I don't want to speak to any prospective legislation because, as Sheena said, the current legislation, the current Severance Payments Act is still in place.
Okay.
Brittany, I'll just add that the Severance Payment Act does make a provision that if and once you reach that 13-week threshold, the employee has the right to trigger severance. It doesn't mean that they must. So for various reasons, an employee might not trigger severance. However, if the employee triggers that severance and gives the employer notice that they intend to apply for severance, the employer has 1 week to reply if they can offer the employee work within a 4-week period. So if within 1 month, I believe I can't rehire you, then I can give you that notice that, okay, I know you're applying for severance. However, within 2 weeks or 3 weeks, I intend to fully re-engage you. The employer can respond to the employee in that way.
Okay. Thank you for that as well, for adding that clarification to the mix. So we have a question here, Brittany. This person is asking you if you can explain the skill comment a little more. The thing is that we need persons at all skill levels, especially in the tourist industry. Are we saying that the room attendant who makes up beds will not be needed in the future, or the beach cleanup person, for example? Everyone plays a role, but I admit that looking at HR management differently is definitely key to proactively responding to the future. So the person's just asking for a little bit of clarity with regards to the comment made earlier about that need for agility in terms of skill set amongst the employees.
Sure. And creating an agile workforce does not mean that we eradicate low-skilled workers. That's not at all what's being stated. But it does mean that we equip those current low-skilled workers with more skills. So of course, there will always be the need for the room attendant. There will always be the need for persons to clean up the beaches. But do we only want those people to have those skills? That's the question that you have to ask yourself. And outside of from a macro perspective and an economic perspective, from an HR perspective, as the person writing the question seems to be writing from, ask yourself from a talent management purview, do you only want people being able to execute one, very discrete function on your property, or do you want multifaceted people? And from a talent management perspective, that's what you want. You want multi-skilled persons. So any way you look at it, it benefits the employer and the employee if we, create not just low skill workers, but workers who have more than one skill.
Okay, all right. And we have one question. Someone's asking how soon are we going to be commenting on the Chefette case? We're going to be starting that shortly. That's the next question, but I have one from the previous discussion that I'm going to ask you. If an employer presents a proposal that will alter your working arrangement, can you present them with a counter proposal?
Of course you can. At the end of the day, you have an initial employment contract which says, I as the employee, I have agreed to do these tasks, and in return, you as the employer, you're going to compensate me this amount. Now, when you're going to alter that contract, dialogue is required on both sides. So if the employer places an option on the table as the employee, if you said, okay, this is interesting, however, I would wish to change one or two of the points, then you enter into the dialogue with the employer on that.
Okay. All right. So you do have that option. Yes, please.
Yes. I'm not sure if you're going to segue right away into the Chefette case, because there's a very interesting comment that I picked up in the Q&A.
Okay. Go ahead. You wanted to respond?
Yes. So there was more of a comment placed and asked for our thoughts regarding NIS legislation and the treatment of contract workers versus professional workers. And I know in the initial discussion, Brittany, what you highlighted, and I agreed with you, looking at the, what is the terminology? The non-traditional forms of work, and how we're seeing the gig economy and those types of things develop and explode. The truth is, we do have some concerns in terms of how do you define what an employee is? Who has a contract for service versus a contract, of service, that age-old argument. And one of the things that I constantly advise employers on, so I'll take this platform and advise them once again, is carefully consider how you are engaging persons. If this person should really be considered an employee, do not place them under the category of a contractor and tell them to pay their own NIS. You have to consider such things as their financial dependence, the provision of tools, and very often the level of control that you want to exercise over this person. And if the person should be deemed an employee, then treat them as such. Just because a person is an employee doesn't mean you have to offer them 40 hours of work every week. Persons can be paid hourly, they can be placed on part-time work. There are different iterations of employment, but they should be categorized as an employee if they really are. Now, when we have some persons who are rendering professional services, whether it be attorneys, accountants, etc., then those persons may be contractors, and then it's their responsibility in terms of registering with NIS and paying their contributions, etc. But within a company, don't always think that your employee must follow the traditional employment contract with 40 hours, and therefore I don't need this person for 40 hours, so I'm going to call them a contractor. Consider it's in the first schedule of the ERA, and there are many articles that you can look at online to consider factors to consider if a person is an employee or not. And if they are an employee, then you can look at crafting an employment contract that speaks to the specific situation of your organization. So I just wanted to share that comment with you guys.
All right.
Marjorie, before we segue, I just wanted to add to that also, because yes, of course, and to add to Sheena's comment, it's about issuing the right type of contract, but it's also equally as important around the operationalization of that contract. So you may issue a person with a contract that is intended to make them a contractor, in parentheses, but then you're paying vacation and you end up paying pension and contributing to the medical plan. So if you issue one type of contract, but you're operationalizing another type of contract, you are also, as an employer, muddying the waters. So sometimes it's less about what you issue and more about how you operationalize, and employers have to be very, very aware of that. I also wanted to add just to that question in relation to national insurance. So I think, yes, the NIS, there are benefits for self-employed persons, but to provide a figure, I think when the Prime Minister first mentioned about the number of self-employed persons who were registered between January and April or something like that with the NIS, it was only like 150. And we do not have 150 self-employed people in Barbados. Anybody knows that. And this is across the region. The informal sector across the region really, really needs to seek to formalize themselves. Otherwise, you will always be hard hit. And it's not just pandemics. We have a hurricane season every year. So there's a likelihood of you being hard hit. So if you are in fact self-employed, you need to go about doing things the right way and formalize the way in which you operate.
All right. Thank you very much. And thanks for where we are thus far in the discussion. We've talked a lot thus far about generally about labor relations. But the Chefette case, as was mentioned, is a specific occurrence, a legal result that happened. We had a ruling from the CCJ, and there has been some discussion in terms of the implications moving forward. So if you can, I'm not sure who wants to lead off, but if you can just go ahead and set the scene and perhaps share with us what are the implications from the outcome, and maybe just say a little bit about the case for anyone who's joining and who may not be fully aware of all of the situation. Okay, Sheena.
Sorry, I was searching for my unmute button.
Ah, okay.
Yes. So the recent judgment, the CCJ judgment in the Orlando Harris versus Chefette Restaurants Limited, that came down, I believe, in May. Well, we're on lockdown, so it was done virtually, and this was from a case arising in 2014 where Chefette Restaurants would have terminated Mr. Harris, and the Employment Rights Tribunal ruled that the dismissal was unfair and made an award of compensation to Mr. Harris in the amount of $106,000. So I think that's about 53,000 US. So for persons who are not in Barbados, so they can have an idea of what the quantum of the award was. And the award was made up of compensation related to loss of employment, and under 3 categories in the Employment Rights Act in that 5th schedule. The company appealed the decision, and at the Court of Appeal, it was upheld once again that the dismissal was unfair, and it was found unfair because of process. Process is where the employer would have fallen down in this case. And the Court of Appeal adjusted the award downward, taking into account notice that was paid previously to the employee. However, the company appealed the Court of Appeal's decision, and that is where it went to the Caribbean Court of Justice. And it was heard in December 2019. And the CCJ once again upheld the decision that the termination was unfair. And as I said, it was deemed unfair because of the process that was followed by the employer in terms of how it reached the decision to terminate Mr. Harris. I would say one of the major factors for us as the BEC and as an employer organization was in the quantum of the award. What the CCJ ruling did was it drastically reduced the quantum of the award. The original award, as I said, was $106,000. I think the CCJ's judgment gave the award of $31,000. So we went from 53,000 US dollars to, that's just about just over 15,000 US. So you can see the award was drastically reduced. And the consideration that the CCJ gave to this case was, when we looked at our Employment Rights Act and the 5th schedule, the compensation was designed to compensate an employee who lost their employment because of an unfair dismissal. It was designed to cover loss of wages, loss of income. So that schedule that outlines what the compensated considered that. The other aspect of compensation that could be awarded should only be awarded where an employee was terminated for an offense that was specifically listed in the legislation. So things such as if an employee was terminated because they had HIV/AIDS, or if an employee was terminated because they became a trade union representative. So those listed ones under, is it section 30, Brittany? Right, so those things listed under section 30, if an employee was terminated for any of those reasons, then additional compensation should be awarded in Orlando Harris's case, that was not the reason for his termination, so he should not have been given an award under that basis. Additionally, the tribunal did have to give consideration to any benefit that he might have lost. But what the CCJ indicated is that benefit is not supposed to be lost wages. That's already covered under the schedule for compensation. That would have to be a benefit that the employee can prove that they lost. So while the tribunal can give a compensation under 3 categories, compensation for loss of wages and earnings, and there's a schedule for that. Compensation because I was terminated under Section 30, so one of those protected reasons, and compensation for a lost benefit, a benefit that does not speak to wages, so a benefit that I would have incurred in addition to my wages. Those are the 3 areas. But in the Orlando Harris case, he should have only been awarded compensation under 1 of those areas and not all 3. And that is the reason for the drastic reduction in the award being granted to Orlando Harris. So that is the case in a nutshell for me.
Okay, so what are the implications moving forward from that ruling? What does that say, therefore, for employers or employees moving forward in the future, being faced with similar circumstances? Are there specific things they should bear in mind? If, for example, the employee wants to be moving forward with a suit, are there certain things employers should be considering if they have to provide defense against such a suit? What are the implications?
I think before we even get to the defense, I think the big takeaway from the case is about process. And I mean, being able to create and mount a successful unfair dismissal case hinges on whether or not you can prove there was a procedural breach. So we just need to be, consistent with the way in which we approach disciplinary action in the organization. We need to have a very proactive manner from an employer perspective with the way in which we revise our policy documents, ensuring that trending breaches and trending things that may warrant disciplinary action are actually reflected in our Code of Discipline as required by the Employment Rights Act. And therefore, if you have to take action based on a breach, that it is clearly outlined what the commensurate disciplinary action is for that breach. So we can't afford any longer to be revising our Code of Disciplines once every 5 years. We can't afford to be updating our handbooks once every 2 years and make them bigger projects. It really has to be an ongoing process to ensure that the policy documents that will eventually get you to places like the CCJ are in fact aligned with your procedural actions. Therefore, when you make or you take a step towards disciplinary action, that it's lucidly clear from both the employer and the employee's purview what breach warrants what commensurate disciplinary action. And if we can start there, really, I mean, cases like this morph into cases like this where, on the ground at the domestic level, there may or may not be consistent updates to these policy documents. So I would say that's the very first step that employers should take.
Okay.
Sheena?
Brittany, I agree with you. Very often, employers have a good reason when they want to separate with employees. However, failure to follow the process is usually where they fall down. And in my experience, sometimes breach of process can be glaring, but there are sometimes I know where employers might have taken certain steps, but they might not have documented it well enough, etc. So you have to be mindful to follow the process at each and every stage, no matter how onerous it may seem, but process is the one thing that will get you all of the time. One of the things I would also wish to highlight about the case is that I wanted to highlight the fact that the CCJ did in fact say that the Employment Rights Tribunal, while they are entitled to make a determination in terms of what they think is the reason for dismissal, in this case, the CCJ thought that the company's reason for dismissal was one that did not need to be challenged, but that the tribunal should have turned its focus to the process followed by the dismissal. So I do know there were some concerns in terms of the tribunal's finding that the reason for the dismissal was not the reason that the company stated. The CCJ did uphold that the company's reason was one that did not need to be changed by the tribunal, and that the tribunal needed to focus on the process. Once again, hammering home what Brittany said and what I said earlier, that the importance of following due process.
Okay. And I think that that is perhaps something that we have been hearing as organizations for years and has always been an issue. The need for documentation, the need for clear guidelines, the need for good policy documents, that transparency, sharing of information, and making sure that when anything is done, that it can be clearly examined from all angles by legal authorities if need be. Brittany, I saw you unmuting. You were about to make a comment?
Yes, there was just a question in the Q&A that's, and I think it's relevant for those who may not be from Barbados. So the reason for the dismissal in the case was non-adherence to a company policy around the changing of checks, and this would be personal checks through the cash register. So that really was the basis. But as Sheena said, the reason for the dismissal was actually or should not have been the focus as the CCJ found. So be cognizant of that when you're reviewing the case.
Okay. And we have a question as well. What is the website for the labor law in Barbados? So for someone who wants to find information about the labor laws, the labor acts and so on, or the Employment Rights Acts or anywhere, where's a website that they can go to find that kind of information?
So the most referenced labor legislation in Barbados can be found on the BEC's website, which is barbadosemployers.com. So www.barbadosemployers.com. We've uploaded, as I said, the most referenced pieces of labor legislation. The CARIBLEX, the ILO, they have a full listing of legislation you can, for the Caribbean actually. So labor legislation that you would find in Barbados and in the Caribbean. I can't remember the name of the website. Actually, I might do a quick search, Brittany, and if you can.
So if you visit the ILO.org website, you can actually navigate from there to the CARIBLEX sub website on their website. So you can go ILO.org.
All right. And so much of this information is available in the territories. And so you can check, as mentioned here, with the ILO website. In Barbados, you can check with the Barbados Employers Confederation website. And for similar organizations in the various territories, even your Chamber of Commerce may have some of that information, or at least could point you to places where you can find out specifics. Now, we've gone a little bit over our usual end time, but I see one last question here that I'm going to throw out to both of you. Someone's asking, suppose your employer cannot pay out for wrongful dismissal, what happens?
Okay, so that question, I have to respond on a couple of fronts.
Okay.
First one is wrongful dismissal speaks of breach of contract, and that has to go through the court system. Anything that's going before the Employment Rights Tribunal will be a claim for unfair dismissal, and that's a claim based on a breach of the Employment Rights Act. So that is going to go through the process of conciliation with the Labor Department before it's referred to the Employment Rights Tribunal, who will then make a determination on if an award should be paid. Now, that award can then be enforced by the court if it's not paid as determined by the tribunal. Now, if the question though, because I know the person said wrongful dismissal, so I'm going to answer on a few fronts just in case they didn't get the right terminology. So if an employer, however, makes an employee redundant, that an employee has worked for 2 years, 104 weeks, that employee is entitled to severance. But there are situations where an employer is not in a financial position to pay severance. So in that situation, the employee needs to make an application for severance payment with the National Insurance Office. and the Severance Payment Tribunal will review that application and make a determination. And once it's agreed that you're due severance, the National Insurance Office will pay that severance to you. If they are going to recover, they'll recover from the business, but they will make the payment to the affected employee. So just in case the person means if the person can't pay severance as opposed to wrongful dismissal.
Okay.
And just so that we are clear also, severance is also triggered in very specific circumstances. So some persons feel as though every time they leave the organization, and they hear the parlance, pay me what you owe me. But that is not always the case. So the base eligibilities that you must, at least in Barbados and in different territories, it is reflected differently. In Barbados, though, you must have been with the employer for 104 consecutive weeks. That would be 2 years of unbroken service. So that's the baseline of eligibility. And therefore, if you're under that threshold, a severance payment wouldn't be payable if you're made redundant, or in the case of the layoff period or the short time, or of a natural disaster. And those are the very specific instances where severance is payable. So severance isn't just something that's paid once the employment contract is closed. It's not paid in all circumstances.
All right, good to know. And as you mentioned, you can reference the websites to get more information on clarity on those situations. So as we are wrapping up now, ladies, I'm going to ask you just to make some closing comments. What would you like to leave with our audience as guidelines for employers or for employees?
I'll go, Brittany. I'll just leave you with this closing thought. Labor relations is predicated upon a relationship between employers and employees. And for that relationship to function and to function well, you need to have dialogue and communication, as in any relationship. That dialogue and communication will serve you well during the good times, where you can introduce new concepts and look at the future of the organization. But it becomes even more critical during difficult times and difficult circumstances. And while we are all operating in a period of uncertainty, and many persons, businesses are in survival mode, we need to continue to have that communication and that open dialogue between employees and employers. A lot of questions we discussed today, and a lot of them can be solved with that dialogue. Sharing of information. How do you resolve issues such as pay cuts? How do you look to agility of the organization in the future? How do you deal with business processes? All of that requires communication and dialogue. So if there's one thing I want to leave with you at the end of today's session, is labor relations, no matter where you practice it, in Barbados, in the Caribbean, wherever in the world, you need effective communication and dialogue to weather the storms that will come. COVID will not be the last one. So you need that to weather all of the storms that will come.
All right. Thank you very much, Sheena. Brittany?
I'd really like to say that I don't think that there's much else to add around, ensuring that you continuously engage. And this is both from an employer and employee standpoint. And a lot of the questions today from employees were, when do I talk to my employer about this? Or when do I, and there's always today. There's always today. Industrial relations is hinged on that mutual relationship of respect and continuous engagement. And if we are always asking when, then that means the breakdown in that relationship is continuously happening, and we see those questions coming from across the region. I'd also like for us really to take away from this, some proactive thought about how do we go forward? How do we continue to build a strong industrial relations system? How do we look at our labor? How do we help to manage our labor at the domestic level in our companies, at the national level if you're contributors to labor policy? How do you help to provide information to policymakers that can help them to bridge the labor gaps that we are seeing across the region? because a lot of the industrial relations unrest that we see and a lot of the issues for industrial relations issues across the region is because a lot of people can't find work. A lot of employers are not fully, sometimes au fait with the labor laws. So how do we fix those bigger issues, which will eventually trickle down to a more happy and pluralistic state of industrial relations? And if we can all contribute in small ways to doing so, I think we can reach a stage across the region where we see industrial relations thriving.
All right, thank you very much. A very positive place for us to wrap up today's discussion. So thank you very much for joining us today. Our topic has been labor relations in the Caribbean. Thank you to our panelists, management consultant Brittany Brathwaite, and the executive director of the Barbados Employers Confederation, Sheena Mayers-Granville. Thank you very much for sharing your insights, your ideas, and your guidance on navigating labor relations at this time in our economic development in Barbados and across the region. For more information on the Sagicor Cave Hill School of Business, on our programs or our activities, please visit our website, uwichsb.org. As always, we invite you to keep the conversation going on our Facebook page and reach out to us if you need any additional information or clarification. You also have the website addresses for the websites you can visit to research and get additional information there as well. Hopefully, you will be able to join us for our next Friday webinar, which is entitled Taking Your Business Online. I look forward to seeing you then. Stay safe, stay sane, and enjoy the rest of your day.
Here at the Sagicor Cave Hill School of Business and Management, located at the University of the West Indies Cave Hill campus, we meet the needs of the upwardly mobile professionals. Our business school functions in an evolving global space where the need to have that competitive edge distinguishes you as a professional. Our academic curriculum offers a variety of programs that gives you that edge. We offer our students a doctorate in business administration. Then, there's our executive masters in business administration. Our Sagicor Cave Hill School of Business and Management is for you. Enroll now.